The European Court of Human Rights has put in place a non-contentious procedure. This is a process which allows you and the government to reach a friendly settlement in your case. It aims to reduce the time taken to resolve cases and allows you the chance to obtain a quick outcome. As from the 1st of January 2019, the post-communication procedure before the court is split into two phases: the friendly settlement phase and the contentious phase. Each phase lasts 12 weeks, but additional time may be granted. In urgent cases, the time is shortened. Upon communication of your case, you will receive a letter from the court. This letter will invite you to think about resolving your case by way of a friendly settlement. The registry of the court may send to you and to the government a draft friendly settlement declaration indicating the terms of a possible agreement. This will happen in most cases, but not in all. One example of an exception is if your case raises a new issue. You are not obliged to sign the declaration. Please note that the proposal of a friendly settlement does not indicate that a violation has occurred. You may offer a proposal or a counter-proposal. You and the government have 12 weeks to agree on the settlement. If you and the government agree on a friendly settlement, the court will strike the application from its list. The execution of the friendly settlement will be supervised, as usual, by the Committee of Ministers. If you refuse the friendly settlement declaration, but the government accept, the government have the opportunity to propose a unilateral declaration. You will then have an acknowledgement that your convention right has been violated and an offer of financial and/or other redress. If you accept, the court will consider that a friendly settlement has been reached. Otherwise, it will examine whether the unilateral declaration constitutes a sufficient basis for striking your application out of the list of cases. If you accept the friendly settlement declaration, but the government declines, the case will move on to the contentious phase. Strict confidentiality is required in all friendly settlement negotiations. This means that you must not disclose the contents of the agreement and of the proposals to someone else until the negotiations have been concluded. There are several advantages to accepting a friendly settlement. 1. You will obtain compensation or redress more quickly. 2. You will avoid further legal costs. And 3. There is no risk of an adverse judgment. Finally, you should be represented by a lawyer during the procedure. With the court's permission, however, you can represent yourself.